I'm going to get started introducing the panel, just so we can stay more or less on schedule. I'm very delighted to be moderating this fourth panel on women's rights, political power, and presence a century later. And I think you'll see, those of you who were participating in the roundtable that we just had, that there's some very clear and direct lines between that discussion and the discussion we're going to have now, particularly with respect to Professor Nadia Brown and Danielle Lemi's paper about Black women and electability and Democratic Party, and with respect to Paul Monopoli's paper on ideas about who can be and should be a political leader and gender schemas. And there's many other issues as well. So the way that we're going to organize this panel is that we're going to hear from two speakers and then have some Q&A, and then hear from two more speakers and have Q&A. But I'm going to introduce everyone all at once just so we can get that out of the way. Our first speaker is going to be Fernie Tolson, who is the Vice Dean for Faculty and Academic Affairs and a professor of law at University of Southern California. She has a book due out next year called In Congress We Trust, ? Enforcing Voting Rights from the Founding to the Jim Crow Era. And following her will be Professor Paula Monopoli, who is the founding director of the Women Leadership and Equality Program at University of Maryland, as well as a Solon Carlyn Hubert Professor of Law, and is the author of the hot off the press book, Constitutional Orphan, Gender Equality and the 19th Amendment. And then after Q&A about their two papers, we will move on to Nadia Brown, who's an associate professor of political science and African American studies at Purdue, and author of the award-winning book, Sisters in the State House, Black Women and Legislative Decision Making. And we may be joined by her co-author, Danielle C. Lemi, who's a Tower Center Fellow at the John G. Tower Center for Political Science at SMU, and has written extensively about representation in American politics, focusing on identity, race, and gender. And finally, my own colleague, Katharine Silbaugh, a professor at BU, who has written extensively about gender, work, family, and household economics, and most recently has focused on youth development, and in particular the issue of 16-year-olds voting. Okay, so that's the introductions. Each speaker will take about 10 to 12 minutes, and we'll start, and you'll be asking questions through the Q&A function. I'll be looking at the queue, and we'll start with Professor Tolson.
Thank you so much, Linda. I'm very happy to be here and to be a part of this conference. So thank you for the planning and everything that went into setting up this very timely conference. So today I'm going to talk about defining the political community of the 19th Amendment. According to John Locke, men are free in a state of nature, but this freedom is divested when men consent to become part of a political community, governed by the consent of the majority in exchange for the peace and security of their property. In turn, the legislative power of the community includes the authority to use the coercive power of the state, mostly to protect it from incursions by outsiders. For Locke, the right to exclude, and in doing so protect the property interests and rights of the insiders, is by definition part and parcel of the Commonwealth's coercive authority. The question of who should be a member of this political community, entitled to vote, is intimately connected to identifying the majority who is empowered to deploy the coercive authority of the state. The US founders, through our governing documents, created two distinct political communities. We the people, who is the sovereign entity that included many, but certainly not all, people such as women, children, propertyless, white men, but not African Americans, not slaves, not Native Americans. So this group nominally holds political power, translated through the medium of representative government. The other group is we the voters, right? A subset of the community of we the people, and is a group that is entitled to deploy the political power on behalf of the majority and elect a representative government. This group consisted almost entirely of property white men. Both groups were designed around Lockean views about the role and purposes of political community as being about separating insiders from outsiders. As voting rights became more inclusive over time, however, the march toward universal white male suffrage represented a full-on assault on the founders' communitarian-based view that initially justified the exclusion of various groups from the community of we the voters. Reconstruction is an important chapter in how republicanism, citizenship, and voting emerged redefined for a new era, blending the boundaries between the two groups, we the voters and we the people, in ways that the US had never before experienced on such a massive scale. Ratified in 1868, Section 2 of the 14th Amendment in particular allows Congress to reduce a state's delegation in the House of Representatives by removing male citizens over 21 years of age from the basis of population used to determine apportionment of representatives if these individuals' right to vote is abridged or denied. While not an affirmative guarantee of the right to vote, its draconian penalty, i.e. reduced representation for voting rights violations, was designed to incentivize states to enfranchise broader segments of their populations. But this provision was not just about punishing Southerners for disenfranchising African Americans. It also formally recognized the political existence of African Americans, a group denied such recognition even with the abolition of slavery. As potential voters, now they had a political identity. This has significant implications for the structure of political community, and by extension, the allocation of political power in the United States. Once Black men were deemed part of the political community entitled to vote in both state and federal elections, states could not abridge or deny their right to vote without creating a government that was non-Republican in form under the Republican Guarantee Clause of Article 4, thereby triggering the penalty of reduced representation. Unfortunately, Section 2's explicit refusal to penalize states for disenfranchising similarly situated women illustrated that we the voters would not reach its full potential in the immediate post-Civil War political order. While the Supreme Court considered women to be citizens despite their disenfranchisement, hence their inclusion in We the People, the 19th Amendment brought them within the political community defined by Section 2 of the 14th Amendment, the revised community of We the Voters, a community based on full citizenship, which conferred upon them a political identity, and equal citizenship, which entitled them to be a holder of rights. The 19th Amendment erased the word male from the text of Section 2, which actually made the US Constitution more consistent with Lockean notions of political community. According to Locke, the mother too had her title, and he actually refuted that husbands were like monarchs with absolute control over their wives. Jeremy Waldron has argued that many of Locke's references to the rights of man in his work were not consistent, and that in some places, Locke evoked man in a gender-neutral sense, in arguing that a natural right of liberty and equality accompanied the notion of motherhood. Nevertheless, the continued disenfranchisement of some white women and virtually all women of color post-19th Amendment through both legal and extra-legal means significantly complicated this narrative. Neither Section 2 nor the 19th Amendment, despite their text, fully rejected antebellum notions of citizenship and community, which emphasized those aspects of Lockean theory based primarily on the community's right to exclude. States that enfranchised women prior to 1920 offered a preview of the fact that limited gender-based restrictions on suffrage, rather than articulating a vision of what voting required, would not be enough to establish women as full participants in the political community of we the voters. In McKenzie versus Hare, for example, the California Supreme Court held that a woman could not vote in state and federal elections because, upon marriage to a British citizen, she assumed her husband's citizenship and was no longer an American citizen, a prerequisite to being an elector in that state. The court determined that her marriage disqualified her as an elector in the context of interpreting a provision of the California Constitution that had been amended in 1911 specifically for the purpose of extending suffrage to women. For decades, resistance to what would ultimately become the 19th Amendment had been centered in traditional ideas of marital relationships and coverture, in which opponents had argued that women did not need to vote because they were represented in the state through the male heads of households. McKenzie illustrated the extent to which this idea continued to live on, even in a political system like California in which women had received the right to vote. The McKenzie decision is no different from early antebellum era voting rights cases, in which citizenship was used as a foil to question the ability of African Americans to be competent electors, even in the context of state statutes that extended suffrage to that community. This aggressive policing of the community of voters, even for those who met the legal requirements to be electors, survived the 14th Amendment, and it would also survive the 19th Amendment, illustrating that disenfranchisement was never about protecting the purity of the ballot box or ensuring an informed electorate. The ratification of the 19th Amendment is an important tributary in the story of voting rights in America because it did in fact bring America closer to a more pure version of we the voters. It ensured more overlap between that category and the category of we the people. Ultimately, the goal should be that more of the people writ large exercise tangible shares of political power in America. But like the 14th Amendment, the 19th Amendment was based on a notion of exclusion that would continue to undermine this vision. When the vote was extended to women, the narrow conception of we the voters was not abandoned, but rather reconfigured to reimagine who was deserving of the vote. The leaders of the women's suffrage movement themselves discussed and perpetuated notions of the deserving voters to allay fears of extending the vote to the poor, the uneducated, foreigners, and Black people. This was an amendment that was largely meant to benefit wealthy white women, and largely did, right, in conjunction with other barriers to voting, such as poll taxes and literacy tests. But even white women faced difficulties in enjoying the right to vote when the right was still tied to antiquated notions of coverture that lived on in marital exclusion laws like that at issue in McKenzie. When considered in light of Section 2 of the 14th Amendment, which altered notions of inclusion in the political community and redefined the standard for Republican government, it is clear that the ratification of the 19th Amendment, in order to be truly effective, required Americans to create an affirmative vision of the right to vote, rather than simply identifying what the amendment prohibits, an oversight that impacts modern conceptions of voting and representation today. Post-ratification, it would take years of litigation and aggressive congressional action for women to truly gain the benefits that they originally sought in fighting for the 19th Amendment. In 1922, Congress passed the Cable Act, separating a woman's citizenship from that of her husband, but did not fully eliminate marital expatriation until 1934. In 1964, the 24th Amendment was ratified, prohibiting the use of a poll tax for voting in federal elections. In 1965, Congress passed the Voting Rights Act, ensuring the enfranchisement of women of color. In this vein, these subsequent developments were just as important as the ratification of the 19th Amendment in ensuring the rights of those entitled to be within the political community of we the voters. These later developments effectively displaced the culture of exclusion that had thrived despite the 19th Amendment, and indeed despite the 14th and 15th Amendments. Thus, the political community of the 19th Amendment, redefined by federal statute and subsequent constitutional amendments to include Black women, poor women, women who married non-citizens, and others, did not become fully formed until almost a half century after its passage. Thank you.
Okay, thanks for being so punctual. Wow. Okay,
I was timing myself.
Unbelievable, great. And now we're going to move on to Professor Paula Monopoli.
Thank you, Linda. I very much appreciate being here today and appreciate the invitation. And also just wanted to say how much I enjoyed the Dean's opening comments about this being a relay. I think that's a great metaphor for this. And also about her description of the women who graduated from BU and all they have accomplished as a native of Massachusetts, someone who grew up in Hadley, the western part of the state. That was really, really interesting information and was very pleased to hear it. So as Linda mentioned, I just published a new book on constitutional development of the 19th Amendment in the decade after its ratification in 1920. And as Linda said, the book is called Constitutional Orphan, and it just came out this month, actually, from Oxford University Press. And it looks at the puzzle of how a thin understanding, a less than robust understanding of the 19th emerged by the end of the decade after its ratification. And it looks at the central role of race, gender, and class in that story, and how the 19th implicated federalism, the scope of women's citizenship, and the constitutional definition of equality. And in that work, I focus on the role of the suffragists as institutional actors in civil society, and that there were many understandings of what the 19th Amendment meant to that diverse group of suffragists. But one common understanding was that it meant political liberty or political freedom. And that sort of notion included full participation in democratic governance in both formal and informal governance. And I read dozens of letters in the archives from suffragists, which all used that phrase, political liberty, political freedom. So in this new paper, what I've done is, and prompted by the deep misogyny of the incumbent president, I want to explore how we measure up to that promise of the 19th in terms of political liberty or political freedom for women. And so what I've done in this paper, I've adapted a framework used by Tom Ginsburg and Aziz Huq in their book, How to Save a Constitutional Democracy, where they look at the connection between constitutional design and the health of liberal constitutional democracies. They lay out a three-part framework to evaluate how likely a democracy is to either be converted to authoritarianism by collapse or even more likely by just democratic erosion. And the metrics that they use are rule of law, liberal rights of speech and association, and free and fair elections. And the latter two metrics, so essential to democratic governance, have also particularly gendered dimensions. And so the full participation of women in our democracy is not only morally right, that parity is central to both the legitimacy of the state and its continued existence. So it's important to examine the role that constitutional design, liberal rights of speech and association, and free and fair elections play in women's ability to engage in democratic governance. So my paper first describes the current state of women's participation in formal and informal governance in our democracy. And it then uses the benchmarks identified by Ginsburg and Huq as a frame within which to identify legislative, judicial, or regulatory mechanisms on the part of the state that could be used to make participation more robust. And my prior work on gender and constitutional design, which I published years ago, and it reminded me when I read this book, suggested that the adoption by the framers of a singular, consolidated executive model for a president, head of state, head of government, and commander-in-chief, all in one person, reflected ideas about the father as the head of the family, and that choice by the framers of this singular, powerful model that combines all three functions made it difficult for voters to match a woman to that role, to the role of the president, the executive, since women are identified with communal traits rather than agentic traits, which characterizes that very sort of consolidated singular model. So it makes it harder for women to ascend to the presidency. And we do better with consensus-based institutions like the courts or legislatures, where voters have less difficulty matching women in communal traits to those roles. And in terms of informal governance and liberal rights of speech and association as a benchmark, in my paper, I note that women are attacked for exercising these rights by our current president, among others, and on the internet in profound ways that chill their speech. And there are few op-eds written and published by women, and I include the statistics about that in terms of engaging in political speech in the public square. And the public square for them is shrinking. And so that's not a good measure if we use that to assess where we are in terms of informal governance, in terms of engaging in political speech and activity. And then finally, the last metric is where do we sit in terms of free and fair elections and the right to participate. And I look there in the paper at the current state statutes, which have a disparate impact on women. So voter ID laws, laws about early access to voting, the laws which are imposing on returning citizens who are being re-enfranchised in terms of having to pay fees and fines before they are re-enfranchised. And those laws all arguably have a disparate impact on women. And again, the intersectional lens, a particularly disparate impact on women of color. So I think in that way, we're not, again, doing as much as we can. If we look at the 19th as the promise of full political participation in both formal and informal governance, we certainly are not reaching its full promise. So the paper concludes with suggestions about how those mechanisms can expand women's formal and informal participation in our democracy. We're not going to get an article, we're not going to get an amendment to the Constitution. Article 5 is too difficult. It's unlikely, but there are things that we can do because the 19th Amendment essentially retrofitted the Constitution and, as Fernita said, expanded the polity, though not as much as we would have hoped, right, in terms of many women not being essentially enfranchised by the amendment. But there are things we can do legislatively, in a regulatory fashion, and judicially to help amp up the promise of the 19th. So things like courts cabining the power of the executive vis-a-vis Congress and making it a less agentic presidency, or building inter-branch connections, making it a more consensus-based model of governance, will help voters more quickly match women to the role of the presidency. And certainly after the last primary season, we are not making progress in that regard. We are, I think, hopefully going to make progress in the sense of having a vice presidential candidate who is a woman of color, and looking forward to that that sort of progress in terms of formal public office holding. It would be remarkable. And then secondly, in terms of speech and association and rights around that, I think regulation in terms of hate speech is important. I know there are trade-offs there, but we certainly, the work of my former colleague, Danielle C, who's now at BU in this area, is an excellent source of ideas for how to protect women's political speech in those forums when we talk about physical and sexualized threats, which chill that speech. And I think finally, in terms of free and fair elections, we could use the 19th Amendment and enforcement legislation, which was never passed under Section 2 of the 19th. It was in the hopper in Congress, and I tell this story in my book about, again, how concerns about appeasing Southern congressmen tended to diminish the chance that enforcement legislation was going to come out of Congress. And when suffragists like Alice Paul turned away from African-American suffragists like Mary Church Terrell, who asked for their help in going after the November 1920 election and helping with voter suppression that had occurred at that moment. And Alice Paul tactically sort of separated race and sex and said, our issues are about sex, your issues are about race. That missed constitutional moment was not only a moral failure, but it was a strategic failure in terms of guaranteeing a narrowing of the 19th Amendment and its power. And so I think in free and fair elections today, we can remedy that failure and 100 years later, use that enforcement power, see if we can get legislation through, which would give us a way to sort of bring intersectional claims in particular against state statutes in terms of their being unconstitutional vis-a-vis the 19th, based on the disparate impact of women and women of color in particular. So I think there is some hope there. And so this more robust participation, if we could use these legislative, regulatory, and judicial mechanisms, would better comport with a thick understanding of the 19th Amendment as securing more than the vote, as securing women's full political liberty. Thank you.
Okay, another right on schedule presentation, actually ending, yeah, perfect, unbelievable. Okay, so people can start typing questions in the Q&A function, and I'll gather those, but I just wanted to put a question to each of the speakers. Professor Tolson, I was very interested in hearing about the continuing power of arguments about women didn't need direct political representation because they could be represented by the men in their lives, like their husbands, their brothers, their fathers. And certainly this was a prominent argument made in the 19th century on both sides of the Atlantic. And Linda Kerber once wrote that the death knell of coverture came in 1992 in the Casey, Planned Parenthood versus Casey joint opinion, where the joint opinion says, we don't have this kind of husbandly control over wives that we once did. That's not our picture. But anyway, my point was more, I was really intrigued about this continuing hold of notions of coverture, even after, in theory anyway, the 19th Amendment was premised on the idea that women should have direct representation and should be able to protect themselves. I don't know if you had anything further you wanted to add about that, but it is striking to think about that through line of those arguments continuing.
I absolutely love that. I didn't know that she wrote that. The invalidation of the spousal notification provisions in Casey, I do think that that's a great way of thinking about that as the end of coverture. But I think one thing that has survived, even if it's not about thinking about women having representation through their husbands or the men in their lives, one thing that has survived is this notion of deservedness. And really goes to something that Paula mentioned in her presentation as well. we don't think about the impact of voter ID laws, felon reenfranchisement, payment of fines and fees on women as much as we do other demographics, in part because women turn out at very high rates, right? And so we tend to sort of discount the barriers that they have to overcome to turn out. And I think part of that has to do with this relatively impoverished view of voting more generally, right? If you want to vote, you can vote. It doesn't matter if the state has placed barriers in front of you that make it difficult for you to vote. If those barriers can be overcome, even in theory, then you should vote, right? And so I think that's one thing that has survived both the ratification of the 14th Amendment, the ratification of the 15th Amendment, and the ratification of the 19th Amendment. And it makes it very, very hard for women to reach their full political identity and full political potential, because we still have this very impoverished view of what voting requires. And so I do think that even if it's less about sort of tying the woman's identity to the men in her life, women are still significantly disadvantaged because that notion of deservedness has survived the ratification of amendments that were supposed to bring them in as full members of the political community. So they're still not, despite Casey, despite the death knell of the Casey sort of posing this death knell to coverage, we're still sort of dealing with some of the things that have honestly survived the antebellum era.
Okay. Anyway, I asked people to send me questions in the Q&A. In the meantime, let me put a question to Paula. Professor Monopoli, I don't know if you had a chance to hear the roundtable that took place with Kelly Dittmar, but one of the interesting things that came up was that one of the troubles in getting women to run for political offices, and this is going to sound kind of like gender essentialism, which I guess will be one of my questions to you, but women tend to want to run for office if they see a problem they want to fix, if they see something that needs to be solved. Whereas men would think, well, why not me? You know, yeah, sure, I can serve. So do you find that in your research in terms of some of the way in which gender expectations or a gender role shape who is viewed as a leader, or why people might think of themselves as a political leader, this notion between wanting to problem solve or fix a problem versus thinking, well, yeah, sure, I can serve?
Yeah, I think that's a really interesting question, Linda. And I think it's connected to what Professor Tolson said about deservedness, right? We internalize those stories about who is part of we the people. And part of the really interesting and I think satisfying discussions about what I call the commemoration of the 19th this summer, not celebration, because it was too, I think, significantly full of holes, if you will, to celebrate, but it's a commemoration, and it's a commemoration of the 150th of the 15th Amendment. And that is that definition of who deserves to be within the polity, right? Who deserves to be within we the voters, I think, as Professor Tolson says. And the thin understanding that came out of that in terms of being simply the ballot, right? And not expansive. And in those 10 years after ratification, it was not jury service for many state courts who construed it. It was not holding public office. Those narratives, many of which have been lost to our collective memory as a historical matter, as a constitutional matter, seep into the populace. And what's fascinating, and there's something that Rachel Tiven said in her roundtable too, that the way we best understand the 19th Amendment is to look not so much at what the suffragists said, and I read a lot of their letters, and they always characterized what they were seeking, or many of them, some much more expansively, but many, as political freedom, political liberty. And they, if you look at the anti-suffragist literature, they were worried about the sort of upending of the social order, right? And how, and in fact, I think many suffragists hoped that that would be the case, but they were politically very strategic and savvy. And so they spoke in terms of political liberty. And so I do think all of that, you know, those different moves that they made, it tended to cabin, right, for years, the idea of women as full citizens, and people internalize that. And so we see that in women candidates today, right? In addition to every other sort of social norm that they've absorbed about themselves. So I do think we still have, but I think that the expressive dimension of a fully amped up 19th would help that problem to some degree.
Okay, I don't yet have any questions from anyone. People are being awfully shy, but let me ask Nadia or Kate if they have anything they'd like to bring into the conversation at this point.
I mean, Nadia, I don't want to cut you off, but I mean, I have to say that I'm immediately driven to thinking about whether despite the effort through those jury service cases, right, and the political office, whether despite those efforts, it was never going to be the case that, you know, how much historical contingency is there to the thicker version of the 19th Amendment? In other words, was it ever going to be possible to extend the franchise and have that stand on its own? Or was it simply, you know, sure, there was going to be push back and forth between the emancipatory and the sort of incremental ideas, but in the end, there's no way that one can extend the franchise in an incremental way. I wonder what, you know, what both of you, Professors Tolson and Monopoli, think about that.
I do think that that is the most likely scenario, is that battling the patriarchy, and the suffragists were only institutional actors within civil society who could only do so much. But I think we underestimate this is a little bit what Jill was talking about, right? When she was saying that, you know, we forget the struggle, but also we forget, you know, women like Florence Kelley, who were incredibly veteran litigators and who had worked Muller versus Oregon and had changed the political landscape and the the relationship between the state and the individual, the relationship between the national government, the federal government, and the states. They did incredible things, and they were involved in this story, and they were involved in this story in really important ways. And so I do think that if we had been able to have women like that answer the call of African-American suffragists after the presidential election in 1920 and use those resources to at least push not only a congressional investigation of disenfranchisement, but enforcement legislation out of Congress. They got a Section 2 enforcement clause, despite enormous pushback against that particular piece. I mean, there was pushback by Southern congressmen against the amendment as a whole, but against the enforcement clause. And they fought back an effort to water it down by saying, you know, amend the amendment to say that the states would have the power to enforce this amendment. And if they did something contrary, then Congress could step in. They beat that back. I mean, so, you know, I don't think it's so out of bounds as a matter of kind of going back and looking at what might have happened, which I don't do a lot of in the book that I just finished, but a little bit of it could have been, when you look at that possibility, that they brought those things to bear. And if we'd had enforcement legislation, it was a very thin version, which was actually introduced into Congress, which died in committee. But if it had looked more like some of the force acts after that had come out under the enforcement clause of the 15th, for example, about jury service, that said right in there, jury service, holding public office, and spoke to state courts and said, this is what Congress means with this amendment, that there might have been at least more acceleration of those attributes of political liberty.
Okay, I had a question from Rachel Tiven saying, could you tell us more, Paula, about how to make it? So how to make a fully substantiated 19th Amendment. I guess you've given a few examples right there, right? Okay, so we should move on then to our second pair of papers. And I think you'll find that Professor Silbaugh's paper directly engages this issue of who are we the voters and what's the community of voters. But we are going to start with Professor Nadia Brown and her co-author Danielle Lemi, I believe, may be joining us. So next is Nadia. Thank you.
Hi, everyone. Thank you so much for being here and allowing me to participate. I feel somewhat like an interloper as a political scientist and someone who most explicitly studies Black women, political candidates, and elites. The title for our paper is Life for Me Ain't Been No Crystal Stair. And this comes from Langston Hughes' poem, Mother to Son, which aptly describes the experiences of the women that we spoke to in our focus group who talked to us about their frustrations with the Democratic Party, but then also expressing some hope from lessons learned for the future. So the fight for women's suffrage, as we learned today, right, it's often lauded as a progressive mark in the American political system. Yet arguments extended the franchise to women were not devoid of using the right to vote to protect white heteropatriarchy and white women's place in upholding white patriarchy and upholding white supremacy. So despite white women's suffrage attempts to keep Black men and women outside of the franchise, ironically, today it is Black women who are key to the success of the party as best situated to produce and protect women's rights, the Democrats. And this is in contrast to what we saw, I guess a couple of weeks ago, pandemic time, a couple of weeks ago, the RNC's highlighting of the Republicans being the party of women's suffrage without taking into account realignment theories. Party realignment. So we present, or we start our paper with Crystal Rita Bird Fawcett, who was the first Black woman duly elected to earn a seat in the state Senate in 1939. She served in the Pennsylvania state legislature. She was an advocate for women's rights and dedicated her life to public service and to political action. She would later go on to organize the Philadelphia Democratic Women's League, and in 1936 became the director of the Black Women's activities for the National Democratic Party. She would later have a close friendship with Eleanor Roosevelt, and be pulled into pretty high-profile Democratic national politics. They later had a falling out, had a disagreement with the party leadership. In turn, she switched her support to Governor Thomas E. Dewey, the Republican candidate for president. And we ground Bird Fawcett's experiences in this paper because they speak to this tenuous relationship with party leadership that Black women have had, like her, and that we see happening now. So why speak to the Democratic Party? Pretty much this is a numbers game, right? More than 97% of Republican women state legislators are white. The majority of women in the Democratic Party and government are women of color. Indeed, the Democratic Party in leadership comprises 36% of minority women in leadership. Also, party ideology matters. The Republican Party increasing conservatism has led to fewer Republican women in general, but also the Democratic Party has had this alliance, this growing alliance with feminist organizations. They've incorporated feminists themselves and policies into the party. The party is now seen as pro-women and is advancing gender rights, as well as key policies, right, like universal pre-K, women's equality. And then can't underestimate the role of racial equality. So once the party of slavery, white supremacy, and segregation, the Democratic Party has transformed itself to be the champion of racial equality. So what we know in the literature about Black women candidates is that they uniformly they're not uniformly supported by their party. In actuality, they have faced a pretty dismal time of being supported by their party. They have difficulty in fundraising. Most specifically, Black women are most likely to have a lot of fundraisers, but gain few amount of money. So picking up $200 here, $150, $500 at max by using these small kind of network level events. Yet and still, right, this is kind of the rub here. They achieve electoral success at outsized rates. And I liken some of this in my past research on their likelihood to champion progressive politics, which helps voters see them as the rightful leaders for issues that they care about. So here's a picture of Danielle and I, my co-author. We've conducted focus groups with the Black Women's PAC. And we really pride ourselves on doing community engaged scholarship. We created this partnership with the Black Women's PAC and working with the community, not to extract from the community, but to give back. So we use our research to center the voices of the people that we study. And we try to help to advance their agendas in some ways, right? How can we use our own research to help them make sense of what they're doing? So we conducted a focus group, the first ever focus group with Black women elected officials and candidates ever. And we had 12 participants. And what I'll show you next are their words around their lack of support for the Democratic Party and their feelings about the Democratic Party in a thematic analysis. So this first quote comes to us from Rachel. And what she's intimately saying is the system is broken. It's not meant for us. So what she says here, as Black women, we really need to develop our own outside of the party system, our own leadership plotline for people to run for office. That's why Black women political practices are so important. So we can do that. And what she's really saying is, right, that Black women who are seeking elected office need to have their priorities matched up, not necessarily what the Democratic Party wants them to do, but they should be able to set their own agendas and then ask the Democratic Party to follow. This next quote comes from a series of thematic examples of Black women talking about the hurt and misgivings they face at the hands of the Democratic Party. From Paula, she says, "But I think that because I found it to be hurtful and I'm angry, because I found that in my party, it is that they would always talk about how we are the biggest voter bloc, but they don't want to give you a position. They select who they want and what they want. They handpick what and who they want." And this is a really emotional point for Pamela. She started to cry during speaking about her past experience as a Democratic Party and feeling used in this very transactional sense of party politics. And this last quote comes to us, these last two quotes come to us from Adele and Tabitha, who are finding their voices and agency, even in spite of some of the things the Democratic Party has done to them. Tabitha says, "A lot of times, even though they look at us as important people to the party," I'm talking about Black women, they're like, "Is she electable?" So this question of we see the need for Black women voters, but we don't know if Black women themselves are electable. Adele says, "I've heard a lot of things, racist words. The party grows a campaign around another candidate, and it's a shame. Black women voters are the backbone of the party." So again, this mashup between being the voters and doing all the work for the Democratic Party, but the party saying racist things about Black women, not putting their resources and support behind them, and also really rushing them off as viable electoral candidates. This longer quote is again from Rachel, and she says, that happened following the party not supporting us, and then charging Black women and judges. And that's just because the women that won election cycle, it's because they just bulldozed their way in and they just decided to run. And so in 2018, when the judges decided to run, they just, so what? None of the campaign people would help us win. And we just went around and did what we know how to do. And that's just what they did. They used grassroots and common sense things. They just went out and started campaigning. And then, surprise, surprise, right? They're on the bench. And which is why people don't feel welcome in the Democratic Party, because people aren't happy about what happened. And even if someone does make it to the bench, sometimes you have to accept it because there are so many of us who will go around the party. And this is a specific example where Rachel was speaking to the 19 Black women in Harris County, kind of encompassing Houston area, where Black women had this landslide victory to the bench in 2018. So to conclude, right, the fight for women's suffrage is often lauded as a mark of progressiveness in the American political system. Yet these arguments extend to the franchise of women were not devoid of the use of the right vote to protect white heteropatriarchy and white women's upholding this. So given now that Black women are the face of the Democratic Party in several state legislatures and on the bench in some places, this data and these experiences that the women shared with us in our focus group may help to move conversation from anecdotes to data-driven analysis and advocating for more resources for Black women candidates. Additionally, Democratic Party elites should take seriously the candidacies of Black women and see them as electorally viable. The party should take an active interest in creating a pipeline of Black women candidates and incorporate them into the party system. They need to take seriously that Black women do not feel included in politics, even after suffrage, and that the Democratic Party should do more to support them. Thank you.
Okay, wow, this is like a record for compliance. I just am amazed. Okay, so, and I know my colleague Kate is going to be wholly compliant, so, because she has to teach later today. So, and now Professor Katharine Silbaugh. You're muted, Kate.
So that's a problem, yeah. I'm just beyond happy to be on the panel with these other scholars because these topics are kind of so nicely woven together, and I'm very honored to be a part of this conversation. I'm basically taking the insights that Professor Tolson and Professor Monopoli were putting forward about the relationship between the vote and civil identity, and this idea that voting will not or would not be an isolated privilege, but it would necessarily be connected to full civil rights at some point. My paper takes that historical account of the 19th Amendment, the account of cohesion between the vote and other civil and political rights, and brings it to a very contemporary debate over 16-year-old voting. So a number of municipalities have recently lowered the voting age to 16, with many more jurisdictions in the Vote 16 pipeline. But the Vote 16 movement has scarcely acknowledged the implications of voting beyond the vote itself. They actually explicitly deny the connection between voting and civil status that the 19th Amendment revealed over time. So their materials say our efforts are only to lower the voting age to 16. All other legal age limits should be set in accordance to what is best for each individual issue. And my conversations with proponents have reinforced that view. 16-year-old voting offers benefits to overall voter turnout and to the voting habit. And that's enough for Vote 16 advocates. They don't wrestle with whether legal adulthood at 16 would become the consequence of their campaign, regardless of their intentions. And then if it is, what child protective values and legal benefits are worth losing in order to achieve the vote. They carve the vote away from the ongoing legal childhood of 16-year-olds. They see voting as incremental, not emancipatory. There is actually a similar story around another extension of the franchise. In 1971, the 26th Amendment granted 18-year-olds the right to vote. Ratification following a several-year campaign triggered by the drafting of 18-year-old men to fight in the Vietnam War. The slogan of that movement was old enough to fight, old enough to vote, thereby marshaling the force of a consistent age-based anchor. Right after the adoption of the 26th Amendment, state legislatures responded by lowering the age of majority for all purposes from 21 to 18. Activists had sought to ignore the question of the age of majority during the debate over 18-year-old voting, just as Vote 16 advocates wish to contain its meaning today, but those wishes didn't prevail. After 18-year-olds won the right to vote, the age of majority did drop in direct response. The 18-year-old vote immediately moved state legislatures in a reflection of the seriousness and weight of the franchise to civil status. As it did for the 19th Amendment, extension of the franchise triggered this wholesale reevaluation of the legal status of the new voter, with both immediate and long-term consequences in both law and culture. That's because voting is not an isolated license. It's a core attribute of civil equality. And almost by chance, 18-year-olds became legally responsible for self-support and housing without much meaningful debate. In moving to lower the voting age to 16, we should do better by acknowledging the significance of the vote and anticipating a wider scope and meaning to enfranchisement. Now, I am personally not actually worried that the votes of 16-year-olds would be immature or would harm the polity. I'm instead asking whether pushing 16-year-olds into the political sphere will hurt them, both by subjecting them to campaign messaging and also by serving as an anchor to a lower age of majority. Because among child welfare advocates, there's widespread consensus that 16-year-olds still need most of the most significant protections associated with their legal minor status, which include rights of material support from their family and the state, protection from exploitation by commercial and government actors, and some forbearance from the state in discipline and criminal process. At the age of majority, a person assumes the legal status of an adult. As a status, adulthood is comprehensive. It's not a series of permissions for particular purposes. Sure, people sometimes enumerate the legal attributes of adulthood as though they are a discrete set of legal changes from being a minor, but that kind of enumeration risks minimizing what is a substantial coherence of the legal age of majority. Enumerators are usually pointing to ages of license, like a license to drive or to drink. The age of majority is different. It entitles a person to live apart from parents, enter binding contracts, become a party to a lawsuit, serve on juries, buy or sell real estate, write a will, enroll in school of your choice, agree to experimental medical treatment, sure. But the most important consequences of adulthood are that they lose the protection of the juvenile justice system and the foster care system, both of which are essential to the protective commitment society makes to children. They lose the right to their parents' financial support and the right to be housed. Those protective rights are the core of the minor status. The 21-year-old drinking age might influence ideas of adulthood in popular culture, but it is an outlier, I think amplified by its singularity. Voting is not such a license. To be a legal minor is to be entitled to support, including housing, and to some measure of forbearance. Indeed, many child welfare advocates are working to extend the protections that now end at 18 to claw back attributes of that 18 adult status. These Raise the Age campaigns have focused on bringing juvenile court jurisdiction and foster care support back to those over 18. Indeed, treating 18-year-olds as adults has contributed in substantial ways to the carceral state, as most people do mature out of criminal offenses. Vote 16 advocates minimize the demonstrated importance of social perception of age within the legal system. That perception influences policymakers when they set ages in code, but it also influences the discretionary decision makers, from school resource officers to community police to prosecutors, whose unconscious adultification, especially of children of color, will be susceptible to the cultural messaging associated with 16-year-old voting. There are a few family law scholars who have observed that the age of majority is a legal construct, and it is, but its constructed nature does not undermine its functional value in protecting and supporting minors. Critiques of the current legal framework undervalue what I call the institutional analysis of legal childhood. That institutional analysis of legal childhood is grounded not in neuroscience or in rights, but in the functional value of a legally recognized institution of childhood, one that draws special resources and consideration to the safety and well-being of children. And the institutional benefit of the minor status also includes legal protection from exploitation by individuals who recognize and would take advantage of the variability in experience and maturity in this age group. Because on the other side of every question of teen capacity is some entity that's constrained in its behavior toward a teenager in the knowledge that it's dealing with a minor. Understanding the legal considerations afforded to minors through that lens of protection against exploitation builds the institutional analysis of the age of majority and explains the law of adolescence as protective when they interact with adults. Example of legal doctrines designed to protect adolescents from exploitation by adults include labor restrictions, the non-enforcement of contracts, the difficulty in releasing liability on behalf of a minor, FTC regulations on the marketing of products to adolescents, and federal statutory protections for adolescents from military recruitment tactics. Each of these legal protections envisions a third party trying to exploit teenagers and builds some barrier to resist it. Yet in adopting 16-year-old voting, we would authorize and invite organized interest to campaign to minors. Parties, causes, commercial interests, they work to form political identities of potential voters as anti-corruption, egalitarian, anti-immigrant, free market, democratic socialist, or white supremacist. All campaigns are going to contemplate the best way to reach teenagers and influence their political development. Campaigns are actively trying to reach teenagers already, and some states protect pre-registered teenagers from aggressive campaign tactics by blocking campaign access to their voter data until they turn 18. And these efforts of campaigns would constitute core political speech protected by the First Amendment. To protect minors from exploitation by interested entities, we're limiting the ability of the military to recruit them, and of commercial interests from holding them to their contracts or marketing to them. And also families and schools are managing the information adolescents receive, both through some limitations and also through involuntarily consumed counter narratives. So to support 16-year-old voting, you must confront the myriad ways that families channel, manage, and limit information in the exercise of their responsibility to nurture adolescents in their development. Even among the teenage political leaders who have emerged in recent years, it's possible to see the hand of enabling parenting, which I detail in the paper. Vote 16 needs to address the ways protected political campaigning to minors conflicts with well-established parental rights and responsibilities to place limits on third-party contact with those minors. Proponents don't consider the current web of regulations restricting speech aimed at minors and do not ask how those regulations will bend the political speech rights of candidates and campaigns. There's a lack of imagination about the changed communication practices that 16-year-old voting would create, impairing a parent's constitutional right to limit third-party contact from gun manufacturers or nicotine companies, and so on. As child welfare advocates seek to protect adolescents from harmful encroachments on the age of majority in the criminal and foster care system, it is essential to evaluate the anchoring role that voting plays and has played in establishing civil, political, and commercial rights in the past. Ideally, that evaluation will cultivate some humility among Vote 16 advocates about their ability to control the social, political, and legal meaning of their campaign to lower the age of the franchise. The legal and political world struggled in the wake of the 19th Amendment to integrate its meaning, pulled between that incremental and the emancipatory conceptions of the franchise for women's rights. Similarly, in the wake of the adoption of the 26th Amendment, some legislators understood the movement as undermining the 21 age of majority altogether, and states rapidly amended their state codes to reflect that broader meaning of the vote. In both cases, there was some controversy. There were incremental and there were emancipatory interpretations of the franchise. But in both cases, emancipatory conceptions were inevitably implicit, even when some proponents tried to defang them. And those emancipatory conceptions would come to reshape legal status well beyond the vote. My paper concludes that Vote 16 risks the erosion of some of the important protective commitments we attach to the minor legal status.
Okay, terrific. I'd like to put one question to Kate and then one question to Nadia and then open it up to colloquy and then also to questions. And I have a couple of questions come in. So Kate, to go back to Planned Parenthood versus Casey again, in striking down the husband notification provision, saying that's inconsistent with present day understandings of the family and the Constitution, the court upholds parental notification because that part of the whole domestic relations that Blackstone gave us, a parent-child, is still sort of intact in terms of parental authority. So my question is, when you talk about capacity and protection, arguments against women having voting rights and indeed full civil and political and economic rights had to do with capacity and the need for being protected by others. Arguments in favor of slavery and segregation relied on racist pseudoscience about capacity. We now think, oh wow, that was the wrong side of history. Those are bad arguments. Yeah. And a lot of people at the time thought that too, right? But so I buy your argument, I pretty much agree, but do you ever ask yourself, what will people 50 years from now say about what I'm saying?
Yeah, I mean, do I ever ask myself, how did I get on the wrong side of Ayanna Pressley and Nancy Pelosi? I do. Yeah. Are you kidding? I 100% ask because they are big proponents of 16-year-old voting, so I think about that all the time. So look, a couple of thoughts about it. One is, I would defend the claim that it was false to say that women lacked the capacity to vote, and there is a question over children. So I would defend that the coverture of children and the coverture of women is different. Not that doesn't mount a complete defense, but I believe they are different. But in particular, I've been working to try to advance this kind of institutional analysis of family law, which basically doesn't get itself preoccupied with the question of capacity, but instead what a framework like that offers. And so we fail in our protective commitment to children. I want to be completely clear about that. We're not successful, and particularly immensely stratified, especially on the basis of race, but on other factors as well. But that protective commitment is interwoven part and parcel with a particular view, which is very much like coverture, which is an idea that we're not going to ask whether every single, we can litigate whether a 16-year-old can emancipate, but this is a rare thing, right? If you're kicked out of the house at 13, 14, 15, 16, the state has to take an interest in it. If you're kicked out of the house at 19, they don't. And that's a really meaningful social commitment. And I would not want to send a 16-year-old convicted of a criminal offense in front of a judge in a 16 voting jurisdiction and have to hear the prosecutor say, this person is old enough to vote. I just think there really is some cohesion to that institutional structure of the age of majority and to the status of being a minor. So I defend it, but I 100% understand the question you're asking. There are some amazing and beautiful stories of minors with incredible political agency, for sure.
Okay, and Professor Brown, in your paper, you didn't get to it in your presentation, but one thing you ponder is, you and Professor Lemi, might it be the case that maybe Black women should explore the Republican Party and see if there's growth opportunities to advance in leadership there? And in our roundtable we just had, Ava Pusateri, who's a Republican, she helps Republican candidates, lamented the great disparity between women's presence in the Republican Party and the Democratic Party. So I'm just curious how viable you think it might be to have growth potential, across party lines with Black women as candidates and representatives.
Yeah, in an ideal world, that would be great. Unfortunately, Blacks are, and many minorities are a captured voting bloc or a captured group because the other party doesn't want them and has policies that makes it very clear their stance on issues that minoritized communities feel strong about. And there's active pushback from trying to include people as full participants, right? So I think having a viable option of other parties would absolutely be the way to go. Unfortunately, it's not practical. And so the women in our studies are really saying they're making the best out of what they're giving, right? They're pragmatic. They understand that the Democrats are the ones who are giving them opportunities. They have a whole lot of gripes about that, but they recognize that in their particular position, there's not an option for them to go to the Republican Party.
And have you, I've seen some stuff on the news about the gender gap among Black voters and how there's a growing percentage of Black men who are voting Republican with each election. And I wonder if your research ever touches on that gender gap at all.
Sure. So it does, not specifically because I don't talk to Black men. That sounds bad. I do talk to Black men. I don't talk to them to do research. But it's so evident it's stark because Black women vote as a highly cohesive bloc, right? So take the 2012 presidential election where Black women voted for Barack Obama at 98%. Even the Stacey Abrams race in 2018, it's upwards of like 96%. Black men are trickling off. They're still high percentage numbers for Democrats, but they're just smaller percentages. So for example, in Florida's last gubernatorial race in 2018, where Andrew Gillum was on the ticket, Black men voted for him at 86%. That in any other demographic group would seem like, oh, that's a great job, it's overwhelming. But when you compare this to Black women who are voting for Gillum at 96%, that kind of breakdown looks a little bit wary. So Black men are just not as cohesive as Black women, but they are more cohesive than any other group that if you wanted to compare them to. They don't have the same kind of gender split that we see for white men and white women, or even for Asian American men and women.
Okay, so I have a question that came in from Professor Nancy Chai-Canalupo, and this really could go to, it was touched by my observation about the research from the previous roundtable that what motivates women may be more to fix a problem. So she asks, I'm interested in comments from any or all of the panelists about the connection between sexual harassment and women getting into politics. The years of the woman in Congress in recent decades have been in 1992 after the Hill Thomas hearings, and in 2018 after the Access Hollywood tape Me Too and Blasey Ford Kavanaugh hearings. Does the problem of sexual harassment and gender-based violence have a particular draw for getting women into politics? Anybody and everybody on the panel can address that.
Well, perhaps I can add some context in a separate project with the colleague Sarah Allen-Gershon at Georgia State. We've been scraping the website candidate bios of women for the last 4 election cycles, and we definitely saw an uptick in particularly Democratic women talking about the impetus for them to run was Me Too and was this Kavanaugh hearings. The kind of interesting part that we're still kind of piecing this together through this research project is that this is primarily coming from white women who were on the sidelines, right? So these were women who were politically engaged in some ways, but were not as fully committed to running for office. So they were like first time candidates, or people that had been kind of on the fringes of electoral politics that were pushed into politics in these ways. This year, what we're seeing is Me Too politics, again, coming out of Tarana Burke, a Black woman, to really specifically speak to the sexual damage and violence that's done to Black women and girls. But this election cycle, what Sarah and I are seeing is the Me Too takes a backseat to Black women who are running around racial justice issues, and particularly in the women that have filed more recently, so their web pages are really highlighting racial injustice and specifically George Floyd, right, and these kind of protests that we've seen.
I think there was a New York Times story about that just a day or two ago about the impact on political action. Breonna Taylor as well. Okay, did anyone else, would anyone else like to take a crack at that question? Okay. So another question came in from Rachel Tibbin, and I had misunderstood her question, which is, Paula, how do we actualize today the full potential of the 19th Amendment?
So I think one of the ways that we can think about using the 19th Amendment, again, in its most fulsome form, is to think about the possibilities of deploying it. And we've seen some nascent efforts in this regard, again, in the Florida litigation, in the Jones versus DeSantis case. There was a 19th Amendment claim. And again, it was focused on the disparate impact to women in the cohort of people who were trying to be re-enfranchised. And that claim, again, was stayed by the court. The trial judge, the federal district court opinion, actually found that the 24th Amendment had been violated, that the fees and fines in the state statute constituted a poll tax, and that went up to the 11th Circuit. The 11th Circuit just recently, Friday, September 11th, reversed, but they were only ruling on the 24th claim, and I don't mean only, it was huge. They were ruling on the 24th in a 6-4 opinion, and said that the 24th had not been violated. This was not an other tax under the 24th, and also reversed the findings in terms of the equal protection clause under the 14th claim, and then the due process clause, which had been a little muddy at the federal trial level, but it was on all of those claims, basically a huge reversal and defeat, I think, for the right outcome. So, but what the 11th Circuit had done is they had essentially stayed the 15th Amendment claim and the 19th Amendment claim that had been brought below. So those will still presumably be briefed. There'll be a panel set up for that, and those will be heard. And again, the idea is that the 19th has some power and it speaks to disparate state statutes which would deprive women of access to voting in terms of voter access generally. In this case in particular, because of the gender pay gap, the inability for people to pay the fees and fines would be the salient factor there. Unfortunately, the trial judge, even though I think he did absolutely the right thing on the 24th, and the equal protection argument, did not let the 19th and the 15th claims go forward because they didn't rise to the level of intentional discrimination / discriminatory purpose, which is required for direct constitutional claims. So, you know, I think there are arguments around that. I don't know if they're going to prevail. It's tough given the jurisprudence and the precedent. But if it doesn't, then I think we need to think about the 19th again as a source of legislation, and either to have a separate piece of legislation around abridging the right to vote based on sex, or, and again, you know, I'd love to talk to people about the notion. There have been a couple of articles which suggested that one could amend the Voting Rights Act to include sex as a criteria, and then get a congressional authorization essentially for a disparate impact claim. So that's today how I think in the voting realm. There's obviously in other scholarship ways to use the 19th synthetically, read it with the 14th in other areas beyond voting. And that's, but in terms of voting, I think that's where we might find some traction.
So people, we have about 15 more minutes. Feel free to send questions through the Q&A. If the panelists would like to make comments on each other's presentations or put any questions, we can do that as well.
Linda, can I speak to the last question?
Sure.
So I think Paula's absolutely right in terms of a potential path forward, but I wonder about if a thicker conception of the 19th Amendment is possible, given that we have an impoverished view of voting more generally, and we have a court that's very hostile to voting rights. I think it makes it difficult to move forward in that space, given where the court is now. Paula's suggestion about the Voting Rights Act, that strikes me as a good way of sort of getting at many of the gender inequities in voting. But I wonder, in light of Shelby County, if that's even possible, given that the court is looking for the intentional discrimination or pattern of intentional discrimination. And it strikes me that it's probably harder to find that intention in the context of gender. I don't want to say harder than race, but it does seem like, you know, in a lot of this, people are not looking at the systematic ways in which women are disproportionately affected by a lot of the inequities in society, as opposed to sort of, you know, setting out to specifically disadvantage women. But I guess a larger point is, I don't think that scholars have to be accepting of this view that the 19th Amendment requires intent, or even the 14th and 15th. I think that if we can get past that, then, you know, it opens the door wide open. I think I'm in the minority in thinking about that, but I study Section 2 of the 14th Amendment a lot. And Section 2 talks about abridgments or denials. It doesn't say anything about intent. It's the only provision of the 14th Amendment that actually mentions voting. Yet we have this whole intent regime that's entirely judicially created. And I just don't think that we have to take that as a given. And so once we challenge that premise, then I do think a lot of the suggestions about using the Voting Rights Act and using more direct enforcement of the 19th Amendment and having federal legislation, I think that we would get a lot further. But we do have to sort of not accept as a given certain priors that I think we do as legal scholars and political scientists.
Yeah, if I could just say, I completely agree. I think the chances under the current regime, both, you know, in terms of precedent and then where we are with the courts, is not robust. We don't have, you know, if I had to predict. But I also think that the 11th Circuit opinion is really interesting because there were six, it was a 6-4. 3 of the 6 joined in this section, I think it's 3B2, which kind of went off on this description of how they were trying to distinguish the 15th and 19th from the 24th. And in doing that, they said some really interesting things about 15 and 19, which was basically, you know, if you could get over the intentional hurdle, that step one in the analysis, and get to the what level of scrutiny you'd use, basically said they were per se rules, and even strict scrutiny, right? They wouldn't even sort of stand up. And so there's some really interesting language in that opinion, which I don't know if it gives us a window, but maybe.
Great. Does anyone on the panel have questions or comments to make about each other's presentations? Because I have more I could ask, obviously, but I want to give you a chance. And it looks like we have a question. Rachel Tiven says, getting away from intent via 14 section 2 is a thrilling idea. Thank you both, and thank you all. Okay, for panel, great. Okay, thank you, Rachel. And we'll look forward to following Rachel on her blog with further adventures about the Daily Suffragist. But does anyone want to raise any questions to each other or make any comments about anything we've heard? Okay, let me pose a question then, if I could. I've had the benefit of reading multiple drafts of some of these papers, because 3 of them are actually going to be contributed to the BU Law Review. So I know some things that they didn't have time to bring up. And based on that, I'd like to ask Nadia, you know, in the roundtable, which we had with Mayor Spicer and Kelly Dittmar and Eva Pusateri and Nina Liang, the mayor observed that people just assume that Black women should represent Black voters, but she is the mayor of a predominantly white city. And it struck me, because in your paper, you talk about the paradox of participation, where despite a lot of the obstacles that Black women experience, they have comparatively better electoral success when compared with Black men and with white women, and that might come from their ability to engage with and empathize with multiple communities. Now, tying this into Paula a little bit, one of the things Paula talks about is, and I agree with her, the threat of toxic masculinity right now in our political leadership, and we've heard endlessly about an empathy deficit right now. So I'm curious if we could talk a little bit about this notion of representation and how that shapes, you know, our idea of who can be a political, who can be a leader and who can they represent, right? That we can have a broader idea of political representation, right? Identity traits are important, but there's not a one-for-one correspondence that, oh, you must have a predominantly Black constituency because you're Black and so forth and so on. So I'd be curious on what Nadia and Paula in particular think, but anyone really can chime in about this.
Sure. Well, I mean, obviously that's an essentialist claim, and I know that you're not making it, but that I think the larger political discourse tends to think that descriptive representation is a monolith, so that you can look at someone, you know, first off and decide what community they're best off to represent, and how does that leave multiracial candidates and representatives. People like we're seeing now, Kamala Harris, which is the work of my my co-author Danielle Lemi, looks at multi-ethnics and how do people, what are we getting wrong with descriptive representation when we're trying to think about people that represent multiple communities. And then also is actually incorrect, right? Black women have been running and winning in majority, non-minority districts. And we see that in this political cycle too. So I think it's this like kind of olden holdovers from the 1990s when majority minority districts were drawn particularly to help Black advancement. I'm thinking about like Shaw versus Reno, and without having a kind of modern uptake. However, right, we know that that's never been, again, a one-to-one correlation, thinking about like a candidate like Charlie Rangel, who is Latino, but has represented, right, a majority Black district, and then has to learn how to branch out to talk to his, will try to reach out and talk to his diversifying constituency. But for Black women, the onus is really on what their politics are, and can they represent marginalized groups and respond to the kind of issues and politics that their communities care most about.
can I follow up just with a question for Nadia? If that's,
yeah.
Sorry. So Nadia, you know, I felt during this campaign as though African-American women had kind of become soccer moms or hockey moms or whatever it was that people used to say was this vote that they were, you know, that everyone began to ask this question after pretty much after the Doug Jones win. And there were all kinds of people all over saying, I'm going to vote for whoever African-American women are supporting, that's who I'm going to support. And I'm curious, you know, aside from sort of a great man and, you know, this is, you know, Jim Clyburn and that's that, besides that story, that I'm curious how the frustration that you put forward in your interviews aligns with how our primary ended up.
Oh, I didn't expect the primary question. Yeah, no, I mean, so it's extremely frustrating, right? Because on one end, right, there is a disappointment with what Black women have actually wanted to do in politics and policy, right? So pushing candidates to be much more responsive to their issues, but yet not seeing a Black woman like Kamala Harris as a person that should be on the top of the ticket. And then, and still, right, seeing this kind of divide between certain segments of Black communities around this individual ticket. But the reality is, right, that Black women voters and elected officials are pragmatic, right? So putting different kind of frustrations aside around policy stances, is this the best ticket to move us forward? But the primaries, right, has been a real disappointment, particularly for me as I was trying to craft this, a research project around this, because I had a different set of expectations. But instead, I think what I should have been looking at is the power behind the scenes. So the Black women, political pundits, activists, politicos who pushed the Biden campaign really hard to get Kamala on the bottom of the ticket, right? That's where the power was. And I think while we were all watching vote choice and trying to match this up to the primary season, I wish our eyes in some ways could have been on, now there is a growing group of Black women politicos that now pull the strings of the Democratic Party, I think largely because Perez and the DNC saw what happened after Doug Jones. And we weren't privy to this behind the scenes. So, you know, it just was this disconnect.
Okay, I have a question from Lauren Mattioli saying, I would love to hear the panelists' thoughts on whether a more robust conception of the 19th Amendment would require using the word gender rather than sex, or if this is not necessary. And if redefinition is not necessary, how trans women locate themselves in the broader struggle for the political integration of women. Anyone can address that. I'm sorry, I muted myself. We had a little discussion earlier in the day, but if anyone on this panel would like to speak to that, be happy to hear it.
I mean, if you had a court system that was, you know, approaching the language of the 19th Amendment in good faith, I think that gender identity would fit fairly naturally there, you know. I mean, I think it's a little like the interpretation of Title VII, you know. I mean, I think, so I would be fairly optimistic, although we're just living in such a weird world right now.
I think I agree with Kate. I don't think that it's necessary. I think that we could use the existing language to be more inclusive. But even as I sort of think through this, I do think that our language is important for reflecting where we are in terms of like to the extent that this is about defining a political community and it's about being more inclusive, language is important, right? But, you know, given the practical realities that it's very difficult to amend the Constitution, that's likely the language that we're stuck with. And so that's why I kind of come down where Katie is, but that does not mean that we cannot adopt that vision through our jurisprudence, through our legislation. So it's probably best to view sex as a floor and not a ceiling.
Okay, I mean, Kate mentioned Title VII and Justice Gorsuch's, implicitly Justice Gorsuch's majority decision on Bostock, which really had not the most robust understanding of sex ever, but it was for a conservative justice rather encouraging, and seemed to recognize the way in which gender role stereotypes, both in terms of how one performs being a man or a woman, and to whom one should be attracted based on being identified man or woman, would be a form of sex discrimination if one is discriminating against because of it. So I think that is a very notable decision, and being able to understand the role of sex role stereotyping and how that affects our understanding of sexual orientation discrimination and gender identity. We're just about out of time. Let me see, I think we've addressed the panel questions. So I would like to, unless anyone on the panel has anything else to say, I think I'll give people a few minutes of extra break. Thank everyone. Thank Danielle. Go ahead. Yeah.
Just a couple of quick questions. Sure. I found my notes. For Professor Tolson, what your view of the idea of an affirmative right to vote, right? An amendment that would give an affirmative right to vote. I think that, you know, unlikely, I agree, but your notion of the political community, the way you described it, sort of reminded me of that.
Paula, please call me Fernita. We're friends now. I'm going to go buy your book as soon as I get off the call. So I adopt a Warren Court view of what the right to vote requires. I don't think that states can put unnecessary barriers in front of the right to vote. I don't think it requires intent. The Warren Court applies strict scrutiny. I think we can get back there. I think that if a state imposes a restriction, they have to justify it through empirical evidence. They can't just say that they need it, which is the world we're living in now. And I think that reflects a more affirmative vision of the right to vote, right? The vision of the right to vote as an actual fundamental right, whereas our current jurisprudence approaches it like it's a privilege, which is why we get back to this notion of deservedness, right? If you can vote if you jump through all of these hoops to vote, and it's incumbent upon the voter to overcome those barriers, as opposed to putting the burden on the state to justify the barriers that they put up. So that's what I mean when I say treating voting as a positive right, as the state having an obligation to make sure that people who are entitled to be within the political community of voters can exercise the right to vote, as opposed to purposely acting to keep people out.
Can I ask then follow up? I'm sorry, Professor Tolson, are children part of the political community?
I
mean, you know, yeah.
Yeah, no, children are part of the broader political community, but not necessarily the political community of we the voters. And honestly, Kate, please call me Fernita. Your presentation made me think more closely about, you know, including children in the political community of we the voters, and the baggage that can come along with that definitely gives me pause. I had just never thought that closely about it. There is a voting rights professor, Josh Douglas, who advocates for voting rights among 16-year-olds. And so I never felt, you know, swayed one way or the other. I could see sort of, you know, allowing 16-year-olds to have some voice in local elections, but I never thought about it in the broader sense of when you give 16-year-olds political rights, then you start treating them like adults, and then they lose sort of the benefits that come with being children in other contexts. And so I really need to revisit my priors on that. So thank you so much for your presentation.
Yeah, and I've tried to, I mean, he and I have gone back and forth, and he's, you know, he just thinks it's not an issue. I mean, he says this is just about voting. This isn't about anything else.
No, it's never just about voting, as we know from the panels today.
So I had an emphatic yes from Gina Shapiro that children are a part of the political community, but we can talk about that more in 15
Oh, Gina,
minutes.
Oh,
yeah,
they
let's
are,
talk.
just not, it's different political communities. Though.
Right. So I'm going to let people take their break and then stick with us, or as Nicole Wallace would say, don't go away. Come back in 15 minutes and we will have our final wrap-up session. So thanks, everybody, for your participation.
So Gina, we'll catch up.
Okay.
Thank you, everybody. This was fabulous.
Okay, and the link to the last session's in the chat, so you can see it there. Okay, thanks, everybody.